However, the Michigan Supreme Court has critically altered MEPA. It diminished access to court for citizens seeking to protect the environment. It narrowed MEPA's scope, limiting the resources that an individual can protect, and shifted MEPA's focus from injury to the environment to injury to the plaintiff. Michigan's Constitution expressly addresses environmental protection. In it, we the people declared that the conservation and development of the state's natural resources is of paramount public concern. We imposed upon the legislature the duty to provide for the protection of the air, water, and other natural resources. To fulfill the Constitution's mandate, the legislature enacted MEPA. MEPA gives any person authority to bring an action to protect the state's natural resources from pollution, impairment, or destruction. For 30 years, there was no question that MEPA empowered private citizens to enforce the environmental laws and to protect the natural resources of the state. The Michigan Supreme Court itself called MEPA significant legislation which gives the private citizen a sizable share of the initiative for environmental enforcement. This was in Eade versus State of Michigan in 1975. Sadly, in 2004, a majority of the present court essentially struck down MEPA's citizen suit provision in National Wildlife Federation versus Cleveland Cliffs. In 2007, it further limited the scope and the focus and altered the focus of MEPA in Michigan Citizens for Water Conservation versus Nestle. In Cleveland Cliffs, the court extended to environmental law cases the standing test that it adapted from federal law in Lee. Mary Ellen described Lee's standing test in her presentation. That test requires the plaintiff to show that he or she was injured in some particular way that is different from the general population. Applying that test to MEPA actions is completely counterintuitive. Because of their very nature, harm to our air, water, and other natural resources detrimentally impacts all of us. Professor Joseph Sachs, who is responsible for drafting the text of MEPA, filed an amicus brief to explain MEPA's purpose. MEPA sought to address the fact that damage to natural resources occurs long before we are actually injured from that damage in our daily lives. MEPA empowered us to stop an injurious act when it first occurred, and not when the resources that were affected by the act were already damaged or had disappeared. As Camp Quality's amicus brief in Cleveland Cliffs points out, if you wait until an individual suffers a particularized injury, such as cancer, from harm caused to the environment, such as releasing toxins into a river, then it's too late to remedy the harm to that individual. MEPA provides for a preventative cause of action for this very reason. Harm to the environment occurs when chemicals are dumped into a lake. By the time that the harm occurs from these chemicals, it's too late to stop them. By requiring a particularized injury, the court requires us to wait until it's too late. As Justice Weaver states in her dissenting opinion in Nestle, the next MEPA case before the court, among the reasons why Article 3-based standing should not be applied to MEPA plaintiffs, the most important is that to do so defeats the clear, unambiguous, and readily understandable purpose of Article 4, Section 52 of the Michigan Constitution. That's the provision that we looked at earlier. The standing test that the majority adopts from federal law is rooted in the U.S. Constitution and simply does not apply to environmental law cases in Michigan. Unlike the federal Constitution, Michigan's Constitution contains a provision specifically authorizing the legislature to pass laws to protect the environment. The legislature, acting under the Constitution's authority, empowered the citizens of Michigan to protect their natural resources. Professor Joseph Sachs explained in his amicus brief that MEPA was designed and structured to fit squarely within the architecture of Michigan's Constitution. In drafting MEPA, Professor Sachs consulted with an advisor to the Michigan Constitutional Convention on the protection of natural resources provision. That advisor offered strong support for MEPA, indicating that it was compatible with the authorizing provision in the Constitution. It's worth noting here that in 1998, in a case called Nemeth versus Abin-Marsh Development, the Supreme Court itself stated that MEPA creates a state environmental law that is unaffected by federal law, and it creates an independent state action that is unaffected by anything that happens in the federal sphere of government. Now, the court has subjected MEPA to a test developed in the federal sphere of government. For 30 years, Michigan citizens were able to enforce laws created to protect the state's environment from harm. After Cleveland Cliffs, however, our right to do so has been significantly impaired.